Good afternoon, everyone. Welcome to Venable's D.C. office and our program today entitled Common Pitfalls and Antitrust Compliance Risks with Association-Sponsored Market Research Programs. Welcome to those of you in person here in our D.C. office, and welcome to those of you across the country who've dialed in for the webinar portion of our program here today. We have a terrific program on a really interesting topic, an area that we here at Venable do a lot of work, and it's an issue that I'm particularly pleased that we're covering today, because for those of you who are part of our monthly seminar and webinar series that we do on nonprofit legal issues, the vast majority of the programs that we do, we try to make sure they have broad appeal to all different types of nonprofit organizations. But sometimes we run into legal issues that are really only applicable to certain types of nonprofits. In the case of today's program, we're talking about trade and professional associations. For the most part, most non-association nonprofits don't deal with these issues. But once in a while we feel it's important enough to cover an issue that's really only relevant to part of our client base and part of the nonprofit community, and today is one of those topics. We are, of course, doing another program later this month that has a wide applicability, but we're glad that you're able to join us for today's program, an area that I think is particularly and personally very interesting. As I mentioned, this is part of the monthly series that we've been doing for 2.5 plus years now on nonprofit legal topics. I know some of you are regular attendees and participants in our programs. I know some of you are new today. Welcome to the program. Today's program is being co-sponsored with the Verus consulting firm, which we're very pleased to be able to partner up with them to deliver this program. I know some of our participants come from Verus's network of clients and contacts in the nonprofit community. Welcome to those of you who are new to our program here today. Let me give you a preview of some of our upcoming programs if any of these topics happen to be of interest. October 24th, our topic is entitled The IRS Final Report on Nonprofit Colleges and Universities, Lessons for All Tax-Exempt Organizations. On November 14th, our topic is entitled Donor Intent, Restricted Funds and Gift Acceptance Policies, What Every Nonprofit Needs to Know to Effectively Accept and Utilize Contributions. And on December 5th, our program is entitled Work and Family, What Nonprofit Employers Should Know About Family-Oriented Employment Laws. A couple of logistics about today's program. We are going to encourage you to ask our panelists questions throughout the program here today. Kelly's here in the back with a microphone, a handheld microphone, which she'll bring around to those of you in the room. Whenever you want to ask a question, just raise your hand. She'll bring it around, and then those of you on the telephone will be able to hear the questions that are being posed. For those of you who are on the phone, pose the questions using the chat feature on the webcast software. I'll be monitoring those at the front of the room, and we'll pose those to our speakers at the appropriate times. Those of you in the room have handout materials that contain a copy of the PowerPoint presentation from today's program, as well as some ancillary handout materials, articles, and the like. Those of you on the webinar should have received a link to the PowerPoint presentation, and everyone will receive an email tomorrow that contains all of the electronic version of all the materials, along with a recording of today's program, along with a streaming PowerPoint presentation, so you can feel free to forward that on to colleagues and others who might benefit from the topic. I want to introduce our three excellent speakers here today, one colleague of mine from Venable and two from Verus. To my immediate right is Andrew Biggert. Andrew is someone with whom I've had the pleasure to work for quite a number of years here at Venable. He's become a very versatile kind of regulatory lawyer in a lot of different areas, so as a result we have the opportunity to work in a lot of different areas. He's a first-rate, outstanding lawyer who has become a key part of our nonprofit practice, especially when it comes to antitrust issues. He's become really our go-to person on antitrust issues facing trade and professional associations. Andrew focuses his practice on antitrust law, consumer protection, international trade, and business counseling. He assists clients with ongoing regulatory compliance matters, civil and criminal investigations, and litigation before the Federal Trade Commission, Department of Justice, Department of Commerce, Department of Treasury, and other agencies. He has significant experience counseling clients in antitrust matters, mergers and acquisitions, advertising and marketing practices, including data privacy and compliance with state and federal consumer protection laws. To Andrew's right is Ian Santodomingo. Ian joined Verus Consulting in 2002. He's a project leader and a hands-on analyst on many of Verus's compensation and benefits benchmarking studies, statistical programs, and trade show audits. He also directs major online market research programs and complex industry statistical reports. For almost 10 years, he's managed the Council of American Survey Research Organization's online compensation and benefits survey and financial reporting program. He also leads the audit team for the Consumer Electronics Show, the largest consumer show in the country. And finally, to Ian's right is Mike Hayes. Mike joined Verus in 2001, and since then has used his extensive experience serving various associations performing highly complex data management and statistical analysis. He manages various projects that collect thousands of data points from dozens of participants on a monthly basis. He works closely with Verus staff to produce effective, in-depth, value-added reports for clients, and he's the final reviewer of survey data and performs final reporting quality checks. We're really pleased to have both Ian and Mike and Andrew here with for our program here today. And with that, I'm going to turn it over to Ian to get us started.
Cool. Thank you. Well, thank you, Jeff. Before we dive into the specifics about antitrust laws, we wanted to go over some of the value propositions of data sharing and market research programs. Some of you may already know a lot of these, but there are numerous benefits to these market research programs. First, it provides an important membership benefit. In our experiences, many of these programs consistently rank in the top 5 and often the top 3 membership benefits. This is something that we see firsthand when we produce membership satisfaction surveys for a lot of our clients. And often they tell us offhand that it is one of their biggest draws to membership and one of their differentiating factors in their association membership benefits. Second, it establishes the association's industry expertise. Third, it also elicits confidence. Reports are based on actual data submitted by participants. Unlike many public sources where data is highly estimated, your program can actually report much more accurate and timely results, since the data we are reporting and publishing is actually data that's coming from your members and directly from them. Fourth, it provides business intelligence metrics not available elsewhere and tracks industry growth in specific segments. Additional benefits for market research programs. First, the data that we publish becomes a differentiator when competing associations exist. This is very important in these competitive markets where you're competing for members and actual retention of them. It stimulates active member participation, which is a critical component to successful organizations. We've seen a few times that it becomes true that these data programs become quite an asset to the organization who is viewed as the expert and the source for the information. It also promotes the association and industry through press releases and data-driven marketing material. And fourthly on this slide, it creates a whole new non-dues revenue stream. We'll talk about these a little bit later, but here are a few of the examples for non-dues revenue streams. Participants can pay to participate. Participants can also purchase the customized reports that come out of these programs. They can also be sold to interested parties through a subscription-based program. And additional topics for meetings or webinars can be gained through these different programs that you conduct. One thing that is relevant now and it's very current is that recently there's been an article published by Bloomberg talking about how the government shutdown is affecting a lot of the data streams that are being published by the Census Bureau and the Bureau of Economic Analysis. One such example was the pig farming industry out of all. The farmers and the commodity markets and the bankers behind the scenes who are driving these commodity markets use a lot of the Census Bureau's data to actually determine pricing, figure out what the supply is in the U.S. of these commodities, these pigs that they're selling into food markets and elsewhere. Because it's not available right now, Bloomberg actually has been reporting that a lot of these analysts and the people and the farmers have been kind of flying blind, trying to figure out what is the appropriate price this quarter for their products. And it's just something that is an opportunity for a lot of associations to complement or supplement with data that they could be collecting and reporting out on a regular basis. It is something that you could even delve a little bit deeper into, because the government tends to publish very top-line figures that help greatly with overall economic views, but when you are an association and these are your members, you can actually delve a little deeper and publish a little bit more detail as to what actually is happening in your own industry. Now I'll hand it over to Andrew to actually give us an overview of the antitrust laws applicable to these programs and how we can all kind of stay safe and within its bounds.
Thank you, Ian. And if anybody can't hear me, please just let me know. So I'm going to be giving an overview of the antitrust laws and then kind of drilling down a little bit more into how they apply to information exchanges, and then conducting an overview of recent developments. And I suppose this is kind of supposed to be the scary part of the presentation on antitrust risks, but hopefully what you can see is that although there are antitrust considerations and the government does on occasion investigate these kind of activities, ultimately if the programs are structured properly and done with advanced thought and planning, you can really minimize the risks of running these kind of programs. And that's what the goal is today, is to show you how to do that. So starting then, what are the antitrust laws? Well, at the federal level, you have the Sherman Act, Sections 1 and Section 2, and the Section 5 of the Federal Trade Commission Act. And these are the main federal laws that govern the antitrust activities here in the U.S. Section 1 of the Sherman Act prohibits all contracts, combinations, and conspiracies that unreasonably restrain trade. That's along with Section 5 of the FTC Act. That's the main law that will apply to information exchanges and benchmarking programs. It covers when you have different competitors coming together and engaging in some kind of coordinated activity. Section 2 of the Sherman Act prohibits monopolization and attempted monopolization, which is not so much of an issue here. And then also it's important to remember that each state has its own antitrust laws, and these generally mirror what happens on the federal level, except for a few kind of isolated issues. So generally speaking, if you're in compliance with the federal laws, you're going to be okay at the individual state level as well. So who enforces the antitrust laws here in the U.S.? Well, primarily at the federal level, it's done by the Federal Trade Commission and the U.S. Department of Justice. They share jurisdiction over antitrust issues. There are some other federal agencies that have some limited antitrust oversight, such as the Federal Communications Commission and a few others. But when it comes to information exchanges and what we're going to talk about today, they're not really relevant. It's more the FTC and the Department of Justice. The current head of the FTC is Chairwoman Edith Ramirez, and on the DOJ side, the Assistant Attorney General for Antitrust is William Baer. Finally, it also bears noting that there can be a private right of action under the antitrust laws that can result in potential penalties, injunctive relief, attorney's fees, etc. So having discussed what the general laws are and who enforces them, let's talk about what kind of activity actually is anti-competitive or could be anti-competitive. And the courts over 100 years now, I guess, have classified activity that raises concerns into kind of two categories. You've got conduct that's been found to be per se illegal, meaning that it's essentially illegal without any regard to its justification or any excuses that you may have. And this covers activities such as price fixing, agreements to rig bids, agreements to limit output, those kind of activities. And those are the activities the courts have found that essentially they're always anti-competitive. The next category of conduct, though, is analyzed under the rule of reason. And this is conduct that isn't necessarily anti-competitive. It's conduct you have to look at kind of the totality of the circumstances to see and balance, what are the potential anti-competitive effects versus what are the potential pro-competitive benefits. This is the test that is used for information exchanges and benchmarking programs. It's also the rule that applies to most association activities, whether you're talking about membership restrictions, for example, or standard settings, the kind of stuff that you probably see in your practices all the time. And why should associations and their members worry about the antitrust laws? Well, as I mentioned, the federal agencies are aggressive in enforcing them. Companies that are found to engage in violations can be hit with large fines. The Sherman Act's a criminal statute, which means in some cases prison may be a penalty as well. And then from the association standpoint, another area that's very important is that the enforcement agencies can seek injunctive relief, meaning in very rare cases they can seek to have an association disbanded. And I think when we get to talking about recent developments, though, what you see will frequently happen if an association or a company is investigated, they end up entering into consent decrees with the agencies where they will agree to not engage in certain conduct moving forward, and they will agree to implement certain compliance procedures and reporting procedures. So from the association perspective, those are kind of the potential penalties you could see for engaging in anti-competitive conduct. All right, so that gives you a general overview of the antitrust laws. That's kind of the Holiday Inn version. You're now an antitrust expert. So now we can kind of delve into actually applying the laws to information exchanges and benchmarking programs. And moving forward, I'm just going to use the term information exchange to cover both because the rules really are the same for both, even though information exchange is more of a general exchange of information between different entities, whereas a benchmarking program is taking data, setting forth kind of how the data is so that people can kind of compare their individual place against that data. The rules, however, are the same, so I'll just use the term information exchange from now on. As noted, it is reviewed under the rule of reason test, meaning you have to balance all of the facts kind of at issue to determine if there is any anti-competitive potential. Some of the key considerations to keep in mind when you're doing that analysis. Well, there's going to be more scrutiny for the exchange of very sensitive information, things like pricing or cost data, output levels, business strategies, and by that it could be a group of companies getting together and talking about what their future product offerings are going to be, for example. There's also heightened scrutiny for the exchange of detailed or firm-specific information, as well as the exchange of information in a highly concentrated industry. And that can be a very important issue. So there's a lot of associations that represent hundreds and hundreds of members, and it's just a very competitive market. And then there can be other associations where it's much more concentrated with just fewer members that have much higher market shares. And in those circumstances, the exchange of information is going to have additional scrutiny. The concern, of course, is that the exchange itself, although not unlawful, could lead to coordinated behavior between the parties exchanging the information. It could lead to coordination on price and to other types of issues. But the other part of the analysis is the pro-competitive benefits, and as Ian described, there's a host of benefits that these programs provide, both to an association in terms of maintaining your kind of thought leadership and helping out your members, to the members themselves who can use these programs to further improve their own business, even to society as a whole. When you've got an information exchange or a program that covers something like best safety practices, for example, in an industry, that's something that directly helps consumers and is something that is certainly very pro-competitive. And so these are all kind of the issues that you need to consider. And fortunately, the FTC and DOJ have helped make the analysis a little bit easier by setting forth a safe harbor for associations to follow. In 1996, together the enforcement agencies issued the Statements of Antitrust Enforcement Policy in Healthcare. And although this was originally focused on the healthcare industry, it's been used by the agencies and by practitioners since then as basically the best practices to go by when running these programs. So let me just cover quickly what the criteria are for the safe harbor. The program needs to be managed by an independent third party. That can be either the association itself or a consulting firm that can come in and help with a lot of the specific logistics of running the program.
But Andrew, just to interject, this is Jeff. Independent third party, the association and DOJ and FTC have made clear the trade association in the industry itself or the profession can be the independent third party. Of course, you can use an outside firm like Beerus or others. But what you cannot use And what the term independent refers to is any of the participating members or companies or professionals who are participating in providing data. None of them should be involved in that role as that independent third-party manager.
That's a great point. So if an association is doing it in-house, you're going to want the employees who are working on that to be independent, just exactly as Jeff described.
Yeah, so if the association is doing it, have staff work on it, but don't have like a member committee like you might have for certain other types of programs.
Great. Thank you, Jeff. The data needs to be more than 3 months old, and the data needs to be aggregated from at least 5 different providers, with no single provider's data representing more than 25% of the information provided. And both of those basically go into the next point, which is that the data needs to be aggregated to prevent identification of provider data. What you can find in some cases, if you're dealing with a very concentrated or small industry, doing an exchange of information, smart people can figure out exactly whose data is what and kind of where the market is. So that's why the agencies want it to be a much broader, more involved process. What does the safety zone actually mean? Well, as described by the agencies, it describes conduct that the agencies will not challenge under the antitrust laws absent extraordinary circumstances, meaning that generally speaking, if you follow the safety zone requirements, there's not going to be any antitrust scrutiny from the enforcement agencies.
Andrew, let me just interject one other point, and this doesn't come from the FTC or DOJ, but actually comes from a colleague of ours who's in the back of the room, George Constantine, co-head of our regulatory practice group, who's done a lot of work with Andrew and me in this area over the years. And I know when George and I have written articles on this topic, and we're adding kind of what are the tips and best practices for kind of staying in this safety zone, George always likes to add a last one, which is make sure you're not providing an opportunity for the members to be able to discuss this data in a way that could facilitate anti-competitive conduct. It's very, very important. Kind of this whole structure kind of presumes that you're going to have this independent third party that gathers certain data, aggregates in a certain way where participants can't be identified, and then it's distributed for people to use as they want. But if you provide a forum, in-person, electronic, telephone, whatever, that's facilitated by the association that allows for the members to be able to discuss this, it can open up a big Pandora's box of dangerous antitrust risks. So that's something to keep in mind.
Yeah, that's exactly right. And as we get into some of the recent developments and looking at consent orders that the agencies have reached with industries, those are some of the types of issues that you'll see as provisions in the consent orders. What kind of compliance best practices should you have in place that go in connection with running these types of programs? But on the other hand, one thing just to note is that the mere fact that a program that you're running doesn't hit all of these particular criteria doesn't necessarily mean that the program is unlawful or raises significant antitrust risk. The safety zone is a starting point, and it's the starting best practices. But depending on the circumstances and with review of counsel and looking at all the circumstances, you don't necessarily have to hit every single one of those. But I would suggest that the starting point should be the safety zone when you're looking at designing these programs. Before getting into some of the recent developments, it's also important to note, especially for associations that have international operations and members, that the antitrust laws exist all across the world, both from a U.S. perspective in terms of potential enforcement if there's an impact here in the U.S., as well as locally where the European Commission, for example, and individual countries have their own antitrust laws. The European Commission, for example, has a antitrust framework that generally mirrors what we do here in the U.S. There are differences, and it's been suggested that for information exchanges they may be more stringent in some respects. But ultimately they do look at the same kind of balancing test, looking at multiple different factors. And we've got some of these up here that you can see. What is the nature of the market? Is it competitive? Is it very focused, et cetera? What's the nature of the information exchange? What type? How old is it? How sensitive is the information? How is it exchanged? Is it aggregate data? Is it made publicly available? And then again, what are the potential pro-competitive benefits for sharing the information? So what's the current state of the law as applied to information exchanges. I would say that there have been a lot of recent developments, and I think they're generally in line with settled law. Maybe a few small little wrinkles that we can kind of highlight for you. But again, I think the starting point is to look at what the safety zone is. Any thoughts about maybe moving away from the safety zone with respect to any of the individual factors is something that should be done just with advanced thought and planning and review by antitrust counsel to make sure that that doesn't significantly increase the risk to an association or its members. So most recently, in fact, just a month ago, the FTC issued a staff letter to the Money Services Roundtable regarding a proposed information exchange by an association of money transmitters, and money transmitters. And just to step back for a moment, both the FTC and the DOJ are very good about issuing staff letters and business opinion review letters, where members of the public, whether an association or an individual company, can write, setting forth facts of a particular activity and request guidance on what the agency's enforcement intention would be. And this allows the agencies to basically provide their views on how particular facts are under the antitrust laws. And so they can be a very good resource for understanding how the laws apply to particular fact patterns.
The only thing I'd add to that, Andrew, is that the FTC and DOJ processes are very helpful and frankly somewhat unique amongst a number of a lot of federal agencies don't offer that option, or if they do, it's a much more complicated, expensive, difficult process. And many trade and professional associations over the years in the antitrust area have utilized that process. And that actually creates a great kind of body of guidance for the rest of us out there to be able to follow. Just keep in mind, though, not in every instance do you want to put your set of facts before a regulatory agency, especially if you're really not sure or you don't have a good sense as to what the outcome might be. That's about the worst thing you can do. Sometimes just simply getting a good reasoned opinion from counsel that stays privileged under the attorney-client privilege is a safer move. But other times there are some really good reasons for doing this.
And fortunately, since there have been a number of them that have been issued, hopefully your counsel will be able to find kind of a situation that's very similar to be able to give you comfort that what you're proposing to do is going to be okay. But they certainly are great resources. And just here, for example, you can see. So just quickly for background, a money transmitter is a non-bank entity that transfers funds between people or entities. And I think just off the top of your head, the biggest one would probably be Western Union or a company like that. And the way that the industry works is that these money transmitters have relationships with grocery stores, for example, or other locations like that, where they will agree to serve as an agent in terms of being able to process and transmit money. The industry is subject to a lot of state and federal regulation when it comes to anti-money laundering and terrorist finance. And so they have a real concern about making sure that they're doing appropriate due diligence on who their partners are to reduce that risk. And so here an association proposed setting up a database where the members could identify agents that they had terminated for cause, so that there would be a resource for the association members when they were doing their due diligence on a potential agent to see if there had been any concerns raised in the past. And so they submitted a request for review to the FTC. And if you have an opportunity to look at the opinion, you'll see that the FTC really did follow kind of the analytical framework that we discussed just over the previous slides. Started out by saying, okay, well, what kind of information is being exchanged? And here it was the name of the exchange member providing the information, as well as identification on the agent that was terminated, date and reason of termination, along with some information on the owners and directors and management of the terminated entities. The FTC then went to look at the structure. How was the information exchange set up? It involved an independent third-party vendor. It was proposed to be open to all non-bank money transmitters. Participation was voluntary. Nobody was forced to participate in this. And then probably most importantly, anyone who did participate in it was not required, was allowed to unilaterally decide whether or not to deal with anybody listed in there. So it wasn't a situation where if somebody was listed, the association was prohibiting its members from dealing with them. So with all those facts, the FTC then did their analysis, and what they found was that the goals of the information exchange, the importance of due diligence and compliance in the industry appeared to be pro-competitive. They didn't see any direct or indirect anti-competitive intent or the attempt to coordinate among members. They noted that the exchange had a number of factors based on the safety harbor, and so therefore the FTC said that they didn't have any enforcement intention, which is kind of the language that they use with respect to this particular exchange.
Andrew, maybe just pause for a second, maybe just help explain to everyone the term that we get so used to doing a lot of antitrust work, but the term pro-competitive. I think most people know what the term anti-competitive means, things that inhibit competition. But maybe helps everyone can get a better understanding what the term pro-competitive means, maybe by giving a few examples too.
Yeah, the term covers benefits that are going to assist consumers and further consumer welfare, and a lot of that has to do with helping businesses expand output, increase output. Those are things that help consumers. The exchange of safety information. You can get into issues such as best practices, and here in that particular issue, the due diligence aspect of it was something that was very beneficial. It can start to get technical from the antitrust perspective as to exactly how to calculate the pro-competitive benefits, because they're generally supposed to be benefits that you couldn't achieve otherwise, kind of absent the activity you were engaging in. But I think just generally speaking, they're the type of activities that will help. They can be activities that both help consumers kind of directly, but also that help your members in terms of helping them expand their business, which is a competitive. That's what we want to encourage. We want to encourage industry to expand, to compete more aggressively, those type of things.
Yeah, the idea being that the more competition there is, the better options there are for consumers to choose from in terms of products and services, and the more it's going to help drive price down. That's what pro-competitiveness ultimately is all about.
Exactly. So moving from the staff opinion letter to a recent consent order that the FTC entered into, where with the staff opinion letter, the FTC found that it was acceptable. This is an example where there were concerns that the FTC investigated, and it started with an investigation into the ductile iron pipe fittings industry, and basically a small association composed of only a handful of members were exchanging competitively sensitive information, sales information, and other items like that. And the FTC was concerned about that this exchange was being used in connection with price fixing. So the FTC investigated. Sigma entered into a consent order early on in the process with them. Some of the other members that were the targets of the investigation actually went through and fought the FTC on it and ended up with a fairly favorable outcome. But what's important about the Sigma consent order here to note is that the FTC actually went further than what the safety harbor requires in some respects. And I think the reason for that is that the FTC viewed this as a concentrated industry, and given the concerns that they had, they felt that it was necessary moving forward to have slightly more stringent limitations on what some of the members could do. So here, one of the individual companies, the consent order requires that any data that exchanges as part of one of these programs be at least 6 months old, whereas in the safety harbor we described it as only 3 months old. They had several provisions going as to what kind of communications could they have about the information exchanges, and the need to have counsel there to help monitor. And I think going to what Jeff was mentioning earlier, these are actually very good best practices that associations should just consider having in general. And we'll get to some of the actual kind of best practices we'll discuss in a few more slides. And the FTC also required that any aggregated industry data be made publicly available, which is not something that the safety zone requires itself. So I think that the takeaway here is that this might be somewhat of a more unique situation because of the competitive concerns in the industry. But it's also a reminder to those associations that maybe do work in a very concentrated industry that sometimes maybe the safety zone, you might want to go a little further and have additional precautions in place.
Thank you, Andrew. And I think it's pretty clear from the safe harbor provisions themselves, but just to make sure everyone's on the same page, one of the primary things that we're trying to, and that the regulatory agencies are trying to prevent here, is the ability for competitors in an industry to utilize data from this exchange of information to be able to collaborate or signal to each other what future prices should be. That's the most dangerous outcome from an antitrust perspective from any of these information exchanges, and that's the number one thing that we're trying to guard against. And so that's why we're talking about using data that's price data that's at least 3 months old, if not more. So it certainly goes without saying that any time that you're talking about future price information, and not even just prices per se, but any other, and it becomes a little bit gray here, but other data that could be a key component in price. If there's an exchange or discussion about information that could be utilized by competitors to determine, well, here's what my competitor may be charging, so here's what I'm going to charge, that is ultimately the most dangerous antitrust violation, price fixing, and that's what we're really trying to guard against the most here. And so just as an aside, once in a while, I don't know how many of you participate on various trade association listservs and other electronic communication exchanges where people are exchanging information. Some of the most dangerous discussions can occur. Well, what are you guys going to be charging next year for this, or for membership dues, for salaries? What are you going to be paying? How much are your benefits going up? These can be very dangerous things to allow to have discussed in any, particularly any electronic exchange that's facilitated by your association. So that's really something to keep a close eye on. Yeah. Let me repeat the question and let Andrew take a first stab at answering. So your question is, you in your association, you ask your members to give kind of big macro forecasts of where they think your industry is going. Do you ask them or allow them to get specific in terms of specific prices, costs, nothing like that? And you're very clear to warn them, can't discuss specific prices, can't discuss specific costs, just more general. What do they predict growth for the industry, that sort of thing, in terms of sales and whatnot?
Yeah, I think that kind of information doesn't really raise real significant concerns, especially when you're dealing with maybe an association that has, not a really concentrated small association. Because, you're not talking about firm real specific information. It's very general, more macroeconomic, as you mentioned, and therefore I just from a very high level, I wouldn't say that there are any significant issues there. But it does raise the important point that most of these surveys start with an information questionnaire that is sent out, and we look at those kind of questionnaires for our clients all the time. And there are times where we do find questions that we do think are too specific, maybe, and so we do encourage it to be more high level.
And also including specific warnings like do not discuss A, B, and C, things that are too specific in that regard. And
just as an aside, a lot of the industry kind of conferences that you might go to, there's often one of the highlights often tends to be that they bring in an expert prognosticator to kind of talk about where the industry is going and et cetera, and they tend to keep it high level, which is good. But it's always funny because I've talked to people who attend these association events, and they always say, well, whenever that person gets up there and tells me, how things are going to be in the future, I always do the opposite because these people never know what they're talking about. So, but yeah, you're definitely right. Keeping it high level is safer for sure.
And to answer that question from Barris's perspective, any survey that we do that is somewhat forward-looking, all of the examples that I can think of, we're collecting information on the overall industry. Anything that's forward-looking is never unique to any specific company, which helps really keep that information general.
Right. And as Mike said, and I think a lot of you have touched, is that it becomes pro-competitive, and a buzzword is competitive intelligence. And I think a lot of it is that you're trying to give a sense to your members that, this is what to expect in general to happen in the next year and sometime in the future, and this is how to plan for your business to grow or meet the demands of what's coming.
We do have a question from the webcast. I think it was sparked by my common example about discussions on listserv about what are you going to be charging in membership dues. And that example came, I see this a lot on, say, various ASAE listservs where the members come from associations and talking about dues. But this is an interesting question where it raises some important points. I think it's worth discussing here, Andrew, for a minute. So the question is, with regard to membership dues, what if the association is the only option in that it's a particular profession? There's no other real competitors to the association. But the real question is, this is a state association. There are various local chapters. The chapters don't compete against each other because they're geographically defined, so a member can only be a member in one of those local components. Can the components who are not competitors themselves share information about prospective membership dues increases, things like that?
I mean, that's a very interesting question kind of from a legal perspective because it gets into, the key focus of the antitrust laws is that they're looking at coordination between competitors. And in that kind of a situation, I can see you making the argument that if these entities don't actually compete with each other, then that competitive concern isn't there and there shouldn't be a risk. I would be pretty cautious about doing that simply because I think you'd want to only reach that conclusion after really looking at the industry carefully, making sure that you understand it. Because any time you've got entities within an association exchanging information, it can look suspicious perhaps, and I don't think you'd want to draw necessarily attention to your association without having kind of had the foresight to look at it, make sure that it's okay, and move forward. So I would say just to be kind of careful in that situation.
Yeah, I would generally agree, although I think if you came to the conclusion that they're truly not competitors, and we've seen this situation in other contexts and associations, and maybe less so these days because competition is so easy to occur electronically, in ways that it never used to before. But I remember when I first started out practicing, a number of our trade association clients would regularly have this practice of getting together say small businesses in different geographic markets. They get together by telephone in person a couple times a year to kind of share best practices, including price and cost and other information. But the association made very clear that these groups of 6 heads of companies, all small businesses, were all from vastly different geographic markets that were not in any way competing with each other, and they felt safe from an antitrust perspective. And we felt safe as antitrust counsel, kind of blessing that. These days, it's a lot harder to come to that conclusion because any small business can be competing with a small business across the country just by selling their goods online, so it's a lot more dangerous in that regard. So I think your words of caution are wise. But if you truly came to a conclusion that these folks are not competitors in any way, then theoretically they should be able to share that kind of data.
Yeah, and that's right. And from the antitrust perspective, when you actually get into litigation, a big part of it is kind of defining what's the relevant market here, who competes against who, and so that's kind of a discussion for another day. But you're absolutely right. I mean, those are kind of the issues that you look at.
I can add to that a little bit also, and I think what Jeff was touching on was perfect. That the distinction is that they have to be completely separate and non-competitive with each other. Mike and I have actually run into this a couple times, and the group tends to be called, in general, called a 20 group. And I think they came up with that name because the number of people or the members within that group have to be less than 20, and I think that was just a legacy term. One of the examples that we came across was that car dealerships. Technically, if you're a car dealership in Tacoma, Washington, and Miami, Florida, you don't compete because your customer base isn't there. So if you make up a group of people who are geographically very different and just not competing, it's possible that they fall within the pro-competitive, framework, and they really just don't, infringe upon each other's territories.
Okay, let's move on.
Yeah. Another recent enforcement action, one that actually didn't involve an association, but it just happened earlier this year, involved hair regrowth manufacturers where the FTC alleged that the CEOs were engaging in direct communications about very sensitive information, as you can see in your slides, issues on future product offerings, prices, et cetera, which the FTC investigated and ultimately reached a consent order. And for purposes of our discussion, again, what's helpful about these consent orders is they kind of highlight for industry, what are the practices that you should have in place to begin with to help prevent this kind of conduct. So they prevent the future exchange of competitively sensitive information between competitors, require annual compliance training for officers, executives, and employees who have contacts with competitors or have sales or marketing responsibilities. And then moving on to the next slide, another consent order that has been held up really as a model of the types of compliance activities that associations should have is the National Association of Music Merchants, which, and by now you can probably see kind of a pattern in how the FTC and the DOJ will work in terms of using the consent orders to kind of establish the types of practices that you should implement. So here, in addition to some of the other things we've talked about, making sure that your antitrust counsel reviews written materials before they're disseminated amongst competitors, making sure that prepared remarks or other issues are fully vetted by counsel. And one of the concerns with the NAM issue was kind of going to what Jeff was talking about earlier, making sure that you've got a great information exchange program set up, but making sure that your members then are not actually engaging in discussions with each other about the outcome of that information exchange and how they're going to use that information. So the association needs to kind of take the lead in terms of limiting members. Each member should be able to review the information, make their own independent decisions, but not be coordinating with their competitors about how to use the information exchange.
And one thing we've seen in the association world is that, and I'm not speaking anything about this particular case, but it's always very important. We're not just talking about formal association facilitated discussions or even association-led discussions where staff is leading a discussion. We're even talking about discussions amongst members that might occur in the hallway of one of your conferences or meetings, which is actually some of the stuff that was alleged in the NAM case. And so what it becomes is very incumbent on the association to be very proactive in not just in the formal information exchanges and the legal notices and warnings and whatnot, and not even on the association-facilitated listservs and other electronic exchanges, but in every setting to be constantly warning and policing your members about what can and can't be discussed. And if you learn of a discussion that was contrary to the association's formally adopted antitrust policy and contrary to the warning that was read at the beginning of the meeting, but you hear a discussion going on, you need to take prompt corrective action. That's the only way sometimes to keep the association itself out of legal trouble. It doesn't necessarily mean that the two competitors who are engaging in anti-competitive discussions aren't going to be held liable, but if you want to keep your association out of trouble and frankly keep your own job, you need to kind of put the kibosh on those discussions. A question right here?
I'm just curious, have you seen an increase of consent or investigations by the Department of Justice or the FTC against associations? Has there been an increase per se?
So the question is, have we seen an increase in enforcement actions by FTC, DOJ, and don't forget, state attorneys general enforce state antitrust laws and other kind of consumer protection laws very regularly, including against associations. And don't forget as well, there's private rights of action, private litigation that can occur. And a lot of times that private litigation, may be by an aggrieved competitor who's suing the association and other competitors believing that they were kind of shut out of some opportunity in the market. Other times, so sometimes that will come instead of or irrespective of any federal or state enforcement actions, and sometimes it comes as a follow-on. Some of the cases that Andrew's reviewing here, once those cases were settled, then we see private lawsuits that occurred in those industries. It's class action suits sometimes that go on for years following. But Andrew, you want to just comment on, has there been any pattern or trend of increased or decreased activity?
Yeah, I'm happy to. And Jeff, you can also kind of chime in on your experiences. I would say that it's not necessarily, I don't think there's necessarily been more of an increased focus on association conduct. I mean, if you look at the antitrust laws and associations, they go back together hand in hand from the very beginning. And a lot of, the very early cases looked at association conduct. It's something that's always been part of it. I mean, after all, associations are generally composed of competitors, and the antitrust laws are focused on interactions between competitors. I will say that the enforcement aggressiveness of the enforcement agencies can go up and down depending on political views, depending on who's in office. There's a lot of perspective out there that the Obama administration is more aggressive when it comes to antitrust enforcement than the predecessor. But I wouldn't necessarily say that I don't think there's been necessarily a concerted effort to go after associations more.
No, I agree. Marlon, do you have a question in the back?
Jeff, can you speak to the exchange of information on social media, Facebook, blogs, tweets, all that, where individual communication between two parties may not be anti-competitive, but the discussion amongst a variety of competitors could raise some questions for association-sponsored social media exchanges?
Yeah, Marlon's question is a great one, and it's an issue that, just in the last week, another colleague of ours and myself gave a couple presentations about social media-related legal issues for associations, not so much focused on antitrust, but focused on copyright infringement and trademark infringement and defamation and privacy. And when it comes to antitrust, the same kind of issues come into play, and that is, so Marlon's question is, in the social media context, to what extent can, or at least I'm interpreting your question to mean, to what extent can associations be held liable for the communications and conduct between and amongst members and or competitors in an industry when sometimes the association has very little, if any, or no control over that social media? Obviously, if it's an association-sponsored listserv, even if it's not staff who are posting the comments, but it's just members who are posting, but the staff is certainly reviewing and has an opportunity to monitor and censor and remove posts and things like that. We've seen plenty of instances where the association can be held liable for that conduct. And while there's a protection for associations under the Communications Decency Act of 1996 for defamation and certain other types of liabilities, that protection does not extend to trademark infringement, copyright infringement, or antitrust violations. There's a separate protection that can be available for contributory copyright infringement. But in the association-sponsored kind of electronic communication vehicle, it's clear that the association itself can have some high antitrust risk. As you get away from association control, then it becomes a lot less clear. And it's going to very much be a facts and circumstance. You got to look at all the different factors. Now, if it's the association-sponsored Facebook page, and it's clear that the association staff has a history of monitoring what's posted on that page, and there's a problematic discussion amongst members, on prices or other things like that, it's certainly conceivable that an antitrust regulator could try to hold the association as well as the competitors liable for price fixing or whatever type of a group boycott, whatever other type of allegation they wanted to bring. If it's not the association-sponsored page, it's just some other social media that the members happen to be communicating with themselves. That's just a vehicle that they're using to communicate, and there's no facts at all that suggest the association or the staff was in any way involved in monitoring, facilitating, editing, etc., those communications. And I think it would be a lot more difficult to hold the association liable. But these are the kinds of things that are very difficult to analyze when you're trying to prove or disprove some liability. But that's why you want to go back to the outset, and you want to try to educate your members. And some of our association clients are extremely well educated when it comes to antitrust issues, and their members and their industry really get it. They know what they can and can't discuss. They've been dealing with this for years. They've heard the warnings, the explanations, the trainings for years, and others are newer to the game. And there's always new members coming into an industry, and it's a constant education process. But the more you educate them, the more you're not only going to help protect the association, but you're going to help protect the members themselves from getting into antitrust hot water.
Yeah, that's exactly right. And just to add one point, when it comes to those kind of communications, another risk is that those are the kind of exchanges that the enforcement agencies or private litigant would love to be able to use as evidence. And so associations always need to be careful, and just like any company does, what do you put in writing? And so if you're talking about an association-sponsored listserv, like a Facebook page or something like that, and it's not being monitored, and some statements are made that raise concern, those could be used later down the line if somebody did investigate, and that's a big part of where that concern can come from as well.
I mean, let's try to get through the last couple
we can,
cases.
I think we'll just jump through this. Just to give you an example, that the DOJ is also involved in enforcement actions as well. And then from a private litigation perspective, That's always something that can happen. There have been a series of lawsuits filed by nurses against hospitals alleging that the exchange of wage information was used by the hospitals to depress wages, and that the exchange was done outside of the safety zone. And these cases are still, at least one case, being worked out. One of them was able to go past the motion to dismiss stage and was recently certified as a class action. So this is just giving you an example of private litigation is also a risk that's out there. All right, and with that, I think we.
Let's move on. And I would also point to your attention some of the articles in the additional information section talk about some other recent cases. There's a few articles that Andrew and I wrote and some of our other colleagues on some of those cases, some very recent and very interesting stuff, and a couple things there from Verus as well. So let's move on.
Great.
Mike?
Great. Next we're going to get into a case study of a new client of ours and just detail the steps that they went through when starting one of these information exchanges from scratch, and how really they were a very thorough process in what they covered from A to Z, and how they minimized their antitrust risks as they moved away from that safe harbor safety zone. So this client, this specific example, is with the manufacturers in the dental implant industry. One thing I'll say up front that is somewhat unique and I would say less than ideal for this group of companies is this program is actually run outside of a trade association, which, as I mentioned, I would say is not the ideal structure for any of these programs. But they obviously had the antitrust rules and issues that were at the forefront of their mind. Their general counsel were involved in all of the initial discussions, and since the program has started, outside counsel has been present at all of the meetings. So the reason for why this program started was that the manufacturers in the industry felt that there was a lack of any reliable market data out there. There were some reports that were produced by different industry consultants, but the general consensus was that those reports, well, one, they were relatively costly, but also that the industry players did not put much confidence in those reports. The methodology of just how that data was compiled was very complex, which is in contrast to the typical association-sponsored program, which has very clear and defined rules and very transparent guidelines. So again, the purpose of starting these reports was to just increase the quality of the market information that's available for this industry. So here's some of the steps and processes that this group went through. I would say that this process, and really applies to any new program that's starting from scratch, but then I think also applies to any changes to an existing program as well. First thing, of course, is to make sure that you have buy-in from the major industry players, especially you don't want to waste potentially any association resources if it doesn't sound like you have buy-in from the key players in the industry. The next step was to draft the standard operating procedures, and we'll talk about some of these specifically a little bit later as we get into some more best practices. But one thing that was very important for this program, and really for any program, is they spent a lot of time up front defining the reporting definitions. This is a global sales report, so there are a lot of, whether it's currency exchange or selling through distributors, are very specific issues that they had to address. And the key thing with starting any program with a very detailed and accurate definitions just ensures that the quality of the reports, make sure that all companies are reporting on a consistent basis. The next step was to consider some type of recruitment material and the process of how they would add new players to this report. As I mentioned, this report was started by just a subset of companies in the industry. However, they wanted to make it clear that participation was open to every company in the industry and, of course, encouraged as well. The final step that they went through was to get a legal review that would give the participants confidence that the antitrust risks were minimized. And then once all of those steps were completed, they could finally begin the data collection process, and we could begin publication of the quarterly reports. I would say for this program, again, they were very detailed and looked at, I think, every potential issue, but it was probably at least a 3 or 4 month process, maybe even more. So I think that's just important to note, that to start these programs and cover all your bases, it's not something that you can start overnight. this is just a brief example of some of the recruitment material that we developed for this client. So the purpose, again, the goal was to expand participation in this program. So we held a variety of of information sessions at various industry events, along with just a lot of follow-up with potential players in the industry, just through email and phone conversations. And again, what was included in this recruitment material and what we highlighted in all of these information sessions was the value of participating in these programs and the value of having accurate information, knowing that these reports would be based directly off of sales data provided by the manufacturers and not some complicated estimation policy or methodology. The final step before we could publish the report was, before we could begin with the data collection, was the legal review. And the purpose of that legal review was to identify any antitrust risks and provide guidance on how those risks could be minimized. The important, and this is a crucial step to have with any new program, but also I would say as a best practice for any existing information exchange or market research program, is something that should be reviewed and looked at periodically as well. So the process of how that legal review worked was the outside counsel conducted interviews with the participants in the program to help determine, as we mentioned earlier, what the pro-competitive reasons were for the program to exist. They looked at our program rules and weighed in on the rules that we had. As I mentioned, this is a global report, so the EU, US, and any other applicable region, they looked at the antitrust laws within those regions. Lastly, that standard operating procedures that we developed, they weighed in on any changes that may need to be made, along with providing guidance on how future meetings should operate, and then more importantly, how make sure we have a thorough and good process to handle any future changes to the program. So once all of these steps were complete, the end result was that the participants were confident that the program risks were minimized, and then they finally moved ahead with the actual data collection program and the publication of reports.
Yeah, interject with a question because it relates to part of what you said, Mike. Certainly, in any data collection effort like this, you want to have kind of a critical mass of industry participants. It's going to make your data more meaningful and make the survey results more meaningful, et cetera. And you want to encourage and even incentivize, and you obviously, in that particular case, worked hard to do that, and it sounds like it was successful. We have seen some associations, clients of ours and otherwise over the years, try to use as such an incentive access to the results, that you're only going to get access to the end result if you participate in the survey. And I wanted Andrew to comment from an antitrust perspective what sort of dangers, if any, can arise from kind of conditioning survey access on participation. We saw earlier in the PowerPoint deck, discussion about how one consent order I think required broad public distribution of survey results. And we saw in the EU that the laws or antitrust, the competition laws are different there in that they require kind of public distribution of those surveys. But say here in the U.S., Andrew, do you want to comment on what sort of antitrust risks or tips you might suggest if an association wanted to condition access on participation in the survey?
Yeah, I mean, I think that's just one of the factors that you would look at when analyzing all the different factors at play for the information exchange. As Jeff noted, it's not one of the requirements of the safe harbor. But it is something that was included by the FTC, for example, in the SGMA consent order. And so I think it's a factor that needs to be looked at and considered, especially if you're dealing with an industry that's highly concentrated, maybe an industry that has had some past issues with antitrust allegations, et cetera. But of course, and in the EU, again, there's a strong push that it always be publicly available. There's also, the kind of a side issue there is in terms of how you price maybe, and if you're pricing and selling this data or making this data, this information that is made for members available to members of the public, do you have to treat it the same way? And just kind of from a very high level, generally, an association doesn't have an obligation to necessarily deal with the rest of the public the same way it deals with its own members in terms of pricing necessarily. But that's kind of a separate issue.
And one other kind of corollary here, but an important antitrust consideration that we see, not with respect to information exchanges, but another common, or maybe not so common as information exchanges, but relatively common trade and professional association activity are group purchasing programs. This is another area of association activity that has serious antitrust consequences, an area that we do a lot of advising and counseling our clients in this regard. That is an area, by contrast, where you cannot, in any instance, or at least do not want to, if you want to avoid antitrust trouble, kind of require members of the association to participate in a group purchasing program and to only buy a particular product and service through the group purchasing program. You certainly want to incentivize it because it can help bring the cost down for everyone, but you absolutely can't require it. Just trying to compare and contrast kind of how the antitrust laws get applied in different settings here. All right, want to move on?
And next we'll get into what we consider some best practices from an antitrust perspective, and also on just how any type of information exchange should be structured to, again, minimize antitrust risk, but then, of course, make sure that there is value provided to your members. And we'll start with some of the antitrust issues.
And I think we'll get through these slides fairly quickly because we've been kind of talking the whole time about the kind of compliance procedures you should have in place. But certainly from our perspective, we advise all of our clients to start with having a antitrust compliance program in place. And there's a couple of different kind of elements that go along with that. Having an antitrust compliance manual put together that provides management, employees, and members with an overview of what are the antitrust laws, what are the key issues for associations, and what's prohibited or risky conduct. Periodic training is very important, especially for certain employees who may have more of a higher risk area. And I think it's also very important, and you see this concept starting to be built upon across a lot of different areas of law, but making sure that whatever compliance program you have is really supported and you've got strong management buy-in. And that's something that the antitrust regulators, but if you're dealing in other regulated industries as well, that's one of the big things that they're going to look at. It's not just having a program in place, it's making sure that the program is supported adequately and that it is actually being followed. And part of the other things the program should cover, for example, having an antitrust statement read or made available in advance of all association meetings.
Yeah, and I guess just to add a little bit to that, in our experience with a lot of the programs that we run, it's actually creating a handbook and, like Andrew said, some kind of manual that can be passed easily between members, and when new contacts are replacing existing ones is actually a nice practice to get used to, because it's a good way for the regulations and the intricacies behind the program to kind of be passed down on an easy, in an easy format. Another thing is also to hold a webinar maybe once or twice a year just for any new faces to the program so that they can kind of just understand the risks and rewards of the program and really the legacy behind it.
Two key points I'd stress here. First off is that you need to make sure you're reaching the whole universe of relevant people. So sometimes associations fall in a trap of just doing antitrust compliance training for the staff, or maybe just for the staff and the board, or maybe for the board and not the staff. You've got to remember, though, there's other key players. There's key committees. There may be other forums where even broader segments of members who are not committee members or board members or officers, but who are still participating and have the ability to engage in anti-competitive discussions or conduct where they really need to be counseled and educated. So every association is different, but you need to make sure that your training is hitting the broad enough audience to be able to guard against the risks that we're concerned about. And the other key thing I'd stress, and that I've learned over the years, and I know Andrew's gotten very good at this, is making sure that your antitrust compliance materials are user-friendly. Cannot tell you, when I started practicing law, I won't tell you how many years ago, and started reading various antitrust compliance policies and manuals to try to kind of learn and see what was out there and educate myself and kind of help myself kind of figure out what sort of an antitrust compliance documents do I want to help start drafting for my clients. Found that so much of this stuff, I couldn't even understand half of what was in there. And it was written in all this legalese and citing cases and just using verbiage that kind of the typical and non-lawyer, or even a lot of lawyers, don't understand. You got to put it in plain English and in verbiage that people can understand. Use examples that are relevant to your industry. I'm a big fan of that in any kind of compliance manuals in any area of law. to bring it home to your industry, use industry-specific examples. If there are cases out there that are very dangerous examples of what not to do, use those examples. And then couple it with training, whether it's in-person, webinars, recorded programs, whatever you want to do that really help to bring it home and make it easy to understand for all the participants.
Great. So I think we've covered really a lot of the antitrust compliance best practices to consider. I think at this point we'd like to turn it back to Ian and Michael to discuss the kind of the practical day-to-day how to do these kind of programs.
Thank you. So we'll start a brief overview of what that third party brings to any program. And as we mentioned earlier, that independent third party could apply to an outside company such as Verus, or of course if it's run by association staff. We stressed earlier the importance really to keep that staff separate from the rest of the organization. That, by limiting who has access to the individual company data, that protects the association, helps limit their liability, and also protects the individual members and participants in these programs. Part of what that third party can do is really help facilitate meeting discussions since they have a deep knowledge base of the program. I think it's important to note that that third party, when it's Verus or that third party would not be the group that's determining, of course, the antitrust and any data retention rules, but they are there to strictly enforce the rules that have been set up for the program and also recommend some additional best practices of ways that the program could be improved. A big step is really one of the main steps that we do is to make sure, ensuring that data accuracy, making sure the reports not only are published in a timely manner, but also that they are as accurate as possible. For some of our programs, we conduct what we call data reviews, where that's just an additional step we take beyond analyzing the data that comes in on a regular quarterly or monthly basis, where we work directly with the finance team of individual companies to make sure that their data from their raw financial system is being mapped accurately to the reporting categories. And really that third party, whether it's that association staff or an independent company such as Verus, they really work closely, and where they'll spend the majority of their time is working with those member companies to make sure that they have processes in place to provide accurate and timely information. So I'll skip over this pretty quickly. This is just an intro slide, some of the additional items that we'll cover from a best practice standpoint. Again, these apply, best practice, I would say, apply on ways to minimize antitrust risk, but from our perspective, it's also ways to make sure that these programs are as valuable as possible and are providing your members with as much value as they can.
So the first, question that I would... sorry about that. The first question that I think a lot of associations grapple with is that what are the most common ways to fund these programs? Obviously, it costs time within your staff, or it'll cost some amount of money to have somebody else run these. And here are kind of like the four ways and the most common ways that we've really encountered. The first is that participants pay and reports are available to the participants only. The second, participants will pay and reports are sold to interested parties, such as a limited subscription program. The third is it's free to participants and reports are sold to the membership only. And the final one that we encounter the most is free to participants and reports are sold to interested parties who are also outside of the actual membership of the association. This becomes a pretty inclusive subscription-based program. And I think Andrew had spoken about this. I might ask you to talk a little bit more about the exclusivity of the data being produced and how publicly available it is, whether an association should limit it to their own membership and really release it to the public or not.
Yeah, I mean, I think it just goes back to knowing your association and your industry, knowing what kind of information you're exchanging, whatever the competitive concerns are, and being able to make an informed decision based on that. There's not necessarily one single right answer, although there are, from a regulator perspective, they would probably want things to always be made publicly available. But that's not to say that that's the end-all, be-all. You want to look at the different options and then kind of identify, what's the risk level here and is that appropriate or not.
And it's also going to sometimes, even within an association, vary on particular types of data that's being aggregated and released, and you have some clients of ours like the National Association of Home Builders and the National Retail Federation who are regularly releasing data to the media and the public that's heavily relied on, in terms of gauging how the economy is doing and things like that. But then they also do other information gathering and exchange amongst their members that may not have the same kind of public distribution.
So I guess, keeping that in mind, what you eventually will use will have to also be what's best and most acceptable to your membership. It will fall within the bounds of safe harbor and antitrust rules, and most importantly, what your participants are willing to accept, because ultimately they will drive this program and they will be the ones who keep this program going. The next best practice we want to actually talk about is pricing considerations. Like, how do we determine a price for the market reports? And when determining the price, there's actually a lot of things to consider. One of the first things is the availability of public data. Is it available from other sources such as the BAA, the Census Bureau, or other associations and other research companies? Another thing to consider is the depth of the data being published. How much detail are we collecting and how much are we publishing and sending back out to our membership? If a lot of times associations are in a position to really gather a deluge of information and be able to publish a lot more than the government or other sources can. First, is it possible to publish this information? And second, if it is, this will become a lot more valuable to your membership, to the participants, and possibly to other people who'd like to subscribe to this program. And so in that case, you have probably a lot more leeway in pricing to the higher end of the scale. And then finally, there's a perceived value to your members in these programs. How important is it to their actual strategic direction and competitive intelligence for their company? How actionable is this information? What can your members actually do with it? If you can answer that, you'll probably have a good idea of the information's value to your members and probably finding the right price point for it to be at. Our next best practice is about meeting procedures and actually talking about and conversations around the data being published. I'll turn that over to Mike.
Thank you. So again, when we talk about meeting procedures and meetings, we are specifically talking about some type of market research committee that meets and gets together for the sole purpose of discussing the information exchange and the industry reports to make sure that those reports continue to provide value to the membership. Like any other association-sponsored activities, these information exchanges should be value-driven and should be driven by member needs. So I think it's as a best practice to have a group of companies that gets together either on an annual or semi-annual basis to discuss the future direction of the program and ways to keep it relevant is very helpful. For that meeting, ideally that would make up all industry participants are eligible to participate and act and be involved with those groups. The key thing is that those meetings aren't just run by, let's say, the 2 or 3 biggest members. You want to make sure you have input from your entire membership base, and also, I would say, a representative sample of your membership would be included in those meetings. Ideally, there would be some legal counsel presence at those meetings. Short of that, and I think part of that will be determined upon the sensitivity of the information that's being discussed at those meetings. Obviously, we've all been in meetings that, at the very least, those meetings will start with that antitrust guidance, going over that view, but that can typically be done by association staff. And as has been mentioned earlier, it's important that those antitrust guidelines don't just apply to what's being discussed in the meeting, but also any side conversations in the hallway, at the cocktail hour, wherever it may be. Lastly, and this is maybe a pet peeve of ours, but definitely a best practice, is that there is accurate meeting minutes are recorded from these meetings. And that those are not just accurate, but also distributed in a timely manner. They'll often leave these meetings with a group of action items for the association staff, third party, along with the member companies. And it's important that those are distributed so companies can begin working on those items while those ideas, of course, are fresh in their head.
Mike, if I can make a few comments. First off, your last comment about meeting minutes, very important, and oftentimes, exhibits A, B, and C that an antitrust investigator or enforcement agency or private plaintiff in discovery is going to be looking at to see what was actually discussed at the meeting. And it certainly is very helpful. The meeting minutes say antitrust counsel was present, gave the antitrust warning at the beginning, stayed throughout to monitor that the appropriate discussions were being had. That sort of thing can be very helpful. And then we had a question from the webinar about should associations ever allow for survey participants to get together and discuss their survey results. I think the easy answer is you can't generalize like that, and certainly as you're pointing out, to say no, those discussions should never be allowed to happen is not practical, and frankly in some cases not in the best interest of the membership to do that. But you cannot also say that there's no antitrust risk. There can be some very serious antitrust risks. So what has to happen is you need to set the agenda of what's on the table and what's not. If you're talking about things at a high level, you're carving out certain things that can't be discussed. And it's one of those instances where I think it's very important to have antitrust counsel present throughout. Not just a lawyer, but a lawyer who really understands these issues and who's not afraid to object and interject, raise her hand and stop a discussion when it goes down a path. Andrew, myself, many others here at Venable have monitored many association meetings over the years, and it can be a very effective tool. I'm not one of those lawyers who believes that you have to have legal counsel present at every board meeting and every committee meeting. That's kind of an old school, kind of long-standing practice. Some of our clients still engage in it. We love to go to their board meetings. Most these days don't, though. They don't have legal counsel at every single meeting. But I do believe that in certain instances, particularly instances like this where there are very antitrust-sensitive topics being discussed, it's one of those instances where I think it's very important to have legal counsel present.
I actually have a follow-up question for either one of you two as well. I purposely wrote accurate meeting minutes on this slide because I have seen there could be a 2-hour meeting and some of my clients that may be very detailed, let's say 5-6 pages of meeting minutes with who spoke when and what they said, whereas other clients it's probably more very much summary format and just summarizes the topics as opposed to getting into too much detail. Is there a better way to handle that?
Yeah, it's a great question, one we get all the time and one we see in practice as we review tons of meeting minutes from board meetings, executive committee meetings, and other meetings from our association clients. As a general rule, what we in our practice advise our clients is that meeting minutes should generally just reflect the actions that are taken at a meeting. So votes, other decisions by consensus. If there's a discussion of a particular topic with no real outcome, you could say that the board met and discussed XYZ topic, period. It's generally not a good practice to talk about what this person said and that person said. It can be actually very dangerous from a legal perspective, not just antitrust, but other legal perspectives as well. Now, that being said, there are some rare instances where it can actually be helpful and protective to the association to put more detail in there, particularly if it's a real sensitive, problematic issue and you want to be able to show that the discussion that occurred did happen kind of in the right way. But that's going to be the exception, not the norm. You generally should never have meeting minutes that are 5 or 6 pages long.
Okay. Next, we can skip over this, just some of the program rules and as far as disclosure of information. These are typically items that would be covered in that standard operating procedures or program guidelines. It's important that all participants in program have access to this information, and then also that any antitrust issues or concerns have been addressed in the formation of any document that thoroughly discusses how the program operates. One item that we do see and we wanted to touch on a little bit is any participation changes that we see in our programs. Obviously, this will depend on how concentrated the industry is, but ideally any program, especially if it's, let's say, a monthly or quarterly program, that the value in it is really looking at that time series of information. Ideally, that participation remains constant so participants can have that called apples-to-apples comparison and draw conclusions based on that data. Obviously, that's not always possible, especially in changing industries. So what we do see for some programs are some types of estimation procedures that supplement the data that's collected directly from the participants and then adds, for that minority of data that you're missing, some type of what we call a projection factor to account for the missing companies. The advantages of some program like this, of some process like this, is that does allow for companies or for participation to change throughout the year and still have that reliable trend line of information. But the other side of that, of course, is the process of how that information is estimated, especially if it's a very detailed, very specific niche category. It may be difficult to come up with an accurate estimate for that.
And just to our audience here and on the phone, we're probably running about 5 minutes over. We should be able to wrap up in about 5 minutes.
Next, just very briefly and very general, the timing of these reports. Reports that we work on range anywhere from the biennial reports all the way down to weekly reports. What we typically see is the more frequent that the reports are published, the less detailed information that is provided. It'll be very, say, top-level sales information, or the results may only be published in, let's say, like an index format. Some things to consider with when timing of reports would be whether the participants are public companies. If so, they may have some types of restrictions on when they can share information externally as related to their quarterly earnings statements. Also, if it's financial information, a lot of surveys that we do collect basically balance sheet type information, so those are typically done on an annual basis. But then when you get into more specific reports that look at, let's say, specific end markets or production information, there's value in what we typically see with those reports, that those are done on typically a quarterly or even monthly basis.
I'm going to take this slide real quickly. Best practices when it comes to copyright, confidentiality, and usage. And the reason we put that kind of subtitle at the top is copyright, confidentiality, and usage. Various areas of law implicated here. First off, we get a lot of questions about, well, if we're an association publishing this very valuable data, how can we protect it, protect others from copying it, from competitors from taking it for-profit or non-profit and utilizing it in ways that kind of cuts into our market share as a publisher and seller of this information. First thing you have to realize is that copyright law only protects kind of creative, original expressions of ideas. It doesn't protect underlying facts or data in and of themselves. So to the extent you're looking for copyright protection, as the author of information, whether you're registering it with the Copyright Office or not, the author of a work is subject to copyright protection if the underlying material itself is subject to copyright protection. The data in and of itself is not, but how the data gets arranged and expressed in a creative, original way can be subject to copyright protection. So most association information exchange reports, like the kind we're talking about here today, are going to be sophisticated enough that how everything's put together should be subject to copyright protection, and you should be registering all of those with the U.S. Copyright Office within the first 3 months of when they're published. But beyond that, the underlying specific data itself likely is not going to be subject to copyright protection. So to the extent you want to protect it, you really have to do it contractually, which means whoever you're going to be giving access to that data, whether it's subscribers, participants who are giving the data and then getting the survey results back, or other members of the media, the public, the consumers that you're selling it to, if you want to put restrictions on how they can use it, you have to do it contractually. You have to build it into that sales agreement. It doesn't have to be a formal contract, but there has to be something where they click and accept that by purchasing this, or even just by getting access to it, even if it's free, that they agree to certain controls, that they can't use it and then compete against you, that they can't sell it to others, that they can't infringe any protections that you have in that. Those sorts of usage agreements where the users are clicking and accepting or signing some affirmative act that they agree to those restrictions on usage are really important to protecting that data. This is obviously very, very valuable stuff. Copyright law can help you to a certain extent, but it doesn't go all the way. Right now we have, I think, one final slide here.
Yeah, I think we just have a couple of slides, and I'll go through these really quick, so just bear with me, and I'll breeze through them. The final slides actually on this topic are about increasing report value. And now that you have a program running, what more can you do? How do you expand upon them and just kind of add dynamic to it? So this list here, 24/7 access to reports, customized market share reports, executive summaries, adding a forecasting component, producing industry summary reports, and hosting webinars and breakout sessions at your conferences to discuss results and other analyses are ways to expand and keep it in the forefront of your membership. We found that the organizations that are the most successful with their market research programs keep it as kind of a cornerstone of their association and continue to enhance it to accommodate their members' ever-growing kind of data needs. Doing so has increased their membership satisfaction rates and even allowed them to profit from some of these programs. The next slides are kind of just examples of value-add reports that we've created for some of our clients and some through very specific market research programs and data or information exchanges. These next two are very static, but these are just examples of customer reports we've created from the programs. These two were created for a specific member with data relevant to their very specific needs. So you see the one in front of you, and the next one is an example of a first page of an executive summary that kind of just makes the results, which tend to be very dense and over 50 to 100 pages long, into a very short and easily digestible piece of literature. The final example I wanted to show you is one we actually work with the Consumer Electronics Association. We've ended up creating a dynamic website for them that was built from scratch through something they envisioned themselves. With our partnership, we were able to kind of bring this to fruition, and it's a site that acts kind of like a banking site where the security and encryption features are behind it, giving their members the confidence to submit and download data via these sites, but also allows them to have a real-time manipulation of the data and analyze what we're publishing on a weekly, monthly, annual basis, so that this data is usable whenever they need it and is always at their fingertips. And with that, that's the end of our session.
All right. Thank you to Mike, Diane, and Andrew for a terrific presentation. Fortunately, we're out of time here. If those of you who are in the room have questions, feel free to come up afterward. Those of you in the webinar, if you have follow-up questions, feel free to email them to me, and I'd be happy to pass them on to our speakers. Or feel free to email them directly. All of their contact information is on this slide, along with links to where you can find a lot of supplemental information on these and other nonprofit legal topics. We hope to see you back here later this month for our second program of October, and otherwise, thanks for participating, and we'll see you again soon.